Criminal Procedure Act. Act No. 341, September 23, 1954. Amended by Act No. 705, September 1, 1961. Act No. 1500, December 13, 1963. Act No. 2450, January 25, 1973. Act No. 2653, December 20, 1973. Act No. 3282, December 18, 1980. Act No. 3955, November 28, 1987. Act No. 4796, December 22, 1994. Act No. 5054, December 29, 1995. Act No. 5454, December 13, 1997. Act No. 5435, December 13, 1997. Act No. 6627, January 26, 2002. Act No. 7078, January 20, 2004. Act No. 7225, October 16, 2004. Act No. 7427, March 31, 2005. Act No. 7965, July 19, 2006. Act No. 8435, May 17, 2007. Act No. 8496, June 1, 2007. Act No. 8730, December 21, 2007. Act No. 9765, June 9, 2009. Act No. 10864, July 18, 2011. Act No. 11002, August 4, 2011. Act No. 11572, December 18, 2012. Act No. 11731, April 5, 2013. Act No. 12576, May 14, 2014. Act No. 12784, October 15, 2014. Act No. 12899, December 30, 2014. Act No. 13454, July 31, 2015. Act No. 13722, January 6, 2016. Act No. 14179, May 29, 2016. Act No. 15164, December 12, 2017. Act No. 15257, December 19, 2017. Act No. 16850, December 31, 2019. Act No. 16924, February 4, 2020. Act No. 17572, December 8, 2020. Act No. 18398, August 17, 2021. Act No. 18598, December 21, 2021. Act No. 18799, February 3, 2022. Part 1 General Provisions. Chapter I Jurisdiction of Courts. Article 1 Investigation of Jurisdiction ex officio. The court shall ex officio investigate jurisdiction. Article 2 Violation of jurisdiction and effect of procedural acts. An action of litigation shall not lose effect by reason of the inappropriate jurisdiction. Article 3 Performance of duties outside jurisdiction. 1. Where it is necessary for the purpose of fact-finding or in case of urgency. the court may perform its duties or take such measures as may be necessary for the fact-finding outside its jurisdiction. 2. The preceding paragraph shall apply mutatis mutandis to a commissioned judge. Article 4. Territorial jurisdiction. 1. The territorial jurisdiction of the court shall be determined by the place of offense, the place of domicile or residence of the criminal defendant, or the place where the criminal defendant is presently located. 2. In respect to an offense committed on board a Korean vessel sailing outside Korea, in addition to the places referred to in the preceding paragraph, the territorial jurisdiction of the court shall be determined by the place where the vessel is registered or the place where such vessel has lain at anchor subsequent to the commission of the offense. 3. The provisions of the preceding paragraph shall apply mutatis mutandis to an offense committed in a Korean aircraft while outside Korean territory. Article 5. Consolidation of territorial jurisdiction. When several cases falling under the territorial jurisdiction of different courts are correlated with each other, a court which has jurisdiction over one of them may exercise jurisdiction over the other cases. Article 6. Consolidated proceedings for territorial jurisdiction. When several correlated cases falling under the territorial jurisdiction of different courts are pending severally in different courts, the next immediately higher court being common to all such courts may, upon request of a prosecutor or the criminal defendant, make a ruling that the cases shall be consolidated in one court. This article wholly amended on December 8, 2020. Article 7. Separate proceedings for territorial jurisdiction. Where several correlated cases falling under the territorial jurisdiction of different courts are pending before one court, and there is any case unnecessary to be examined by consolidation, the said court may separate and transfer it to other court having jurisdiction, by its ruling. Article 8. Transfer of case ex officio. 1. If a criminal defendant is not found in the district under the territorial jurisdiction of the court, and if there are any extraordinary circumstances, the court may, by its ruling, transfer the case to an equivalent ranking court which has jurisdiction over the place where the criminal defendant is presently located. 2. Where a case under the jurisdiction of a single judge is changed into that of the collegiate body of a court due to amendments to the bill of indictment, the court shall transfer the case to the court having the jurisdiction over such case, by its ruling. Less than newly inserted on December 29, 1995 greater than. Article 9. Consolidation of substantive jurisdiction. When several cases the substantive jurisdiction of which is different, are correlated with each other, the collegiate body of the court shall exercise jurisdiction over all of them by consolidation, provided that the court may transfer the case to a single judge of a court having jurisdiction over the cases, by its ruling. Article 10. Combined proceedings for substantive jurisdiction. When several correlated cases the substantive jurisdiction of which is different are severally pending before the collegiate body and a single judge of a court, the collegiate body of a court may, notwithstanding the jurisdiction of the subject matter, examine by consolidation the case belonging to the jurisdiction of the single judge by its ruling. Article 11. Definitions of correlated cases. Related cases shall be as follows. 1. Any case concerning multiple offenses committed by one person. 2. Any case concerning an offense jointly committed by several persons. 3. Any case concerning offenses committed individually by several persons at the same time and at the same place. 4. Any case concerning an offense of harboring an offender, suppression of evidence, perjury, false expert testimony, or interpretation, or an offense relating to the stolen goods, and an offense of the primary offender thereof. Article 12. Lie pendens of one and same case before two or more courts. When one and the same case is pending before two or more courts the substantive jurisdiction of which is different, it shall be examined by the collegiate body of the court. Article 13. Concurrence of jurisdiction. When one and the same case is pending before two or more courts the substantive jurisdiction of which is identical, the court in which the public prosecution therefore has first been instituted shall examine the case, provided that the next immediate higher court being common to all such courts may, upon application of a prosecutor or the criminal defendant, require the court in which the prosecution therefore has been instituted later, to examine such case by its ruling. This article wholly amended on December 8, 2020. Article 14. Request for designation of jurisdiction. In the following cases, a prosecutor shall apply to the next immediate higher court being common to the first instance court concerned for the designation of jurisdiction. 1. When the jurisdiction of the court is not clear. 2. When there is no other competent court in respect to such case as the decision declaring the inappropriate jurisdiction therefore has become final and conclusive. This article wholly amended on December 8, 2020. Article 15. Application for transfer of jurisdiction. In the following cases, a prosecutor shall apply to the next immediate higher court for the transfer of the case to other court. The criminal defendant may also do so. 1. When for a legal reason, or owing to extraordinary circumstances the court having jurisdiction is unable to exercise its judicial power. 2. When owing to the nature of the offense, the popular sentiment of the district, the circumstances of the proceedings, or any other circumstances, there is any apprehension that an impartial trial cannot be maintained. Article 16. Form of designation of jurisdiction and application for transfer. 1. In cases of an application for designation of jurisdiction or transfer to other court, a written application stating the cause shall be submitted to the next immediate higher court. 2. When an application for designation of jurisdiction or transfer to other court is made after the institution of the prosecution, the notice thereof shall be immediately given to the court in which the prosecution has been instituted. This article wholly amended on December 8, 2020. Article 16-2. Transfer of cases to military court. When a military court comes to have jurisdiction over a case in which public prosecution has been instituted or it is found that the military court has jurisdiction over such case, the relevant court shall, by its ruling, transfer such case to the military court having jurisdiction of the same instance. In such cases, the acts of litigation already done before the transfer shall not lose the effect thereof by reason of the transfer. Less than amended on November 28, 1987 greater than. This article newly inserted on January 25, 1973. Chapter 2. Exclusion, challenge and refraining of court officials. Article 17. Reasons for exclusion. In the following cases, a judge is excluded from the exercise of his/her duties. Less than amended on March 31, 2005, December 8, 2020 greater than. 1. Where the judge himself/herself is a victim. 2. Where he/she is a relative of a criminal defendant or a victim or had a kinship with such person. 3. Where he/she is the legal representative, supervisor of guardianship of the criminal defendant or the victim. 4. Where he/she has become a witness or an expert witness in regard to the case, or has become an agent of the victim. 5. Where he/she has acted as the representative, counsel or assistant of the criminal defendant with respect to the case. 6. Where he/she has exercised the duties of a prosecutor or a senior judicial police officer pertaining to the case. 7. Where he/she has participated in the decision by the court below or investigation or trial which constituted the basis thereof in the case. 8. Where 2 years have not passed from the date the judge retired from a law firm, limited liability law firm partnership, law office, or joint venture law firm under subparagraph 9 of Article 2 of the Foreign Legal Consultant Act, which is the defense counsel of the criminal defendant or the representative of the criminal defendant or victim with respect to the case. 9. Where 2 years have not passed from the date the judge retired as an executive officer or employee of a corporation, institution, or organization which is the criminal defendant. Article 18. Reasons for challenge and person entitled to apply for challenge. 1. In the following cases, a prosecutor or the criminal defendant may challenge a judge. 1. If a judge falls under any of the reasons referred to in subparagraphs of the preceding article. 2. If there is any apprehension that a judge may render an unfair judgment. 2. A counsel may file an application for challenge against a judge only when it does not go against the express will of the criminal defendant. Article 19. Jurisdiction over motion for challenge. 1. The challenge against a judge who is a member of a collegiate court shall be applied to the court to which the judge belongs, and the challenge against a commissioned judge, requisitioned judge, or single judge shall be filed against the relevant judge. 2. A cause of challenge shall be made by preparing presumptive proof in writing within 3 days from the date on which the application has been filed. Article 20. Dismissal and management of application for challenge. 1. An application for challenge which evidently aims at delay of the proceedings or contravenes the provisions of Article 19, shall be dismissed by a ruling by the court or judge who has received such application. Less than amended on December 29, 1995 greater than. 2. The judge who has been challenged shall submit a written opinion on the application for challenge without delay, except as provided in the preceding paragraph. 3. In the case of the preceding paragraph, when the challenge judge considers that the challenge is reasonable, the ruling thereof shall be deemed rendered. Article 21. Decision on application for challenge. 1. The decision on an application for challenge shall be determined by a ruling of the collegiate body of the court to which the challenge judge belongs. 2. The judge who has been challenged shall not participate in the decision referred to in the preceding paragraph. 3. Where the court to which the challenge judge belongs does not constitute a collegiate body, the next immediate higher court shall decide it. Article 22. Application for challenge and suspension of proceedings. Where an application for challenge has been filed, the proceedings therefore shall be suspended except as provided in Article 21, provided that this shall not apply in case of urgency. Article 23. Dismissal of application for challenge and immediate complaint. 1. An immediate complaint may be filed against a ruling by which an application for challenge is dismissed. 2. The immediate complaint to a ruling on dismissal under Article 21 may not suspend the execution of trial. Less than newly inserted on December 29, 1995 greater than. Article 24. Causes for refraining. 1. Where a judge considers that there is any cause which falls under Article 18, she shall refrain from passing on the matter. 2. An application for refraining shall be made in writing with the court to which a judge belongs. 3. Article 21 shall apply mutatis mutandis to the application for refraining. Article 25. Exclusion, challenge, and refraining of court officials. 1. Except as provided in subparagraph 7 of Article 17, the provisions of this chapter shall apply mutatis mutandis to court administrative officers and clerks in grades IV through 7, hereinafter referred to as court officials and interpreters. Less than amended on June 1, 2007 greater than. 2. The ruling on challenges against court officials and interpreters under the preceding paragraph shall be rendered by the court to which they belong, provided that a ruling under Article 21 shall be rendered by a judge of a court to which such challenged person belongs. Less than amended on June 1, 2007 greater than. Title amended on June 1, 2007. Chapter 3 Representation and Assistance for Acts of Litigation. Article 26. Persons devoid of mental capacity and representation for acts of litigations. In a case involving a criminal offense to which Articles 9 through 11 of the Criminal Act do not apply and the criminal defendant or the criminal suspect is devoid of mental capacity, she shall be represented by her legal representative in regard of acts of litigation. Less than amended on June 1, 2007 greater than. Article 27. Juristic persons and representation for acts of litigation. 1. When the criminal defendant or the criminal suspect is a juristic person, it shall be represented by its representative in regard of acts of litigation. 2. Even when a corporation is represented by two or more persons jointly, it shall be represented by each of them severally in respect of acts of litigation. Article 28. Special agents for acts of litigation. 1. When there is no person to act for, or to represent, the criminal defendant in accordance with the provisions of the preceding two articles, a special agent shall be appointed by the court ex officio or upon request of a prosecutor, and where there is no person to act for, or to represent, the criminal suspect, a special agent shall be appointed by the court upon request of a prosecutor or any interested person. 2. A special agent shall perform her duties until there is another person to pursue the acts of litigation as representative for or on behalf of the criminal defendant or the criminal suspect. Article 29. Assistance. 1. The legal representative, the spouse, a lineal relative, or a sibling of a criminal defendant or a criminal suspect may act as her assistant. Less than amended on March 31, 2005 greater than. 2. Where no person capable of acting as an assistant exists or where a person is unable to act as an assistant due to disability, etc., a person who has a reliable relationship with a criminal defendant or a criminal suspect may act as her assistant. Less than newly inserted on July 31, 2015 greater than. 3. A person who intends to act as an assistant shall file a report on her intention with the competent court at each level. Less than amended on June 1, 2007, July 31, 2015 greater than. 4. An assistant may independently perform acts of litigation which do not go against the express will of the criminal defendant or the criminal suspect, provided that the forging shall not apply where otherwise provided in acts. Less than amended on July 31, 2015 greater than. Chapter IV Defense. Article 30. Persons entitled to appoint defense counsel. 1. A criminal defendant or a criminal suspect may appoint a defense counsel. 2. The legal representative, the spouse, a lineal relative, or a sibling of a criminal defendant or a criminal suspect may independently appoint a defense counsel. Less than amended on March 31, 2005 greater than. Article 31. Qualifications for defense counsel and special defense counsel. A counsel shall be appointed from among attorneys at law, provided that in extraordinary circumstances, any court, other than the Supreme Court, may permit the appointment as a counsel, who is not an attorney at law. Article 32. Effect of appointment of defense counsel. 1. An appointment of a defense counsel shall be submitted in each instance of court in writing under the name and seal of the defense counsel. 2. An appointment of a defense counsel effected prior to the institution of public action shall remain in force in the first instance. Article 32-2. Lead defense counsel. 1. Where there are two or more defense counsels, the presiding judge may designate a lead defense counsel upon the application of the criminal defendant, the criminal suspect, or the counsel and may revoke or change such designation. 2. Where no application under paragraph 1 is filed, the presiding judge may designate a lead defense counsel ex officio and may revoke or change such designation. 3. The total number of lead defense counsels shall not exceed 3. 4. Notice or service of documents to a lead defense counsel shall be binding upon all the counsel. 5. Paragraphs 1 through 4 shall apply mutatis mutandis where there are 2 or more defense counsels for the criminal suspect and a prosecutor designates a lead defense counsel. This article newly inserted on December 29, 1995. Article 33. Court-appointed defense counsel. 1. In any of the following cases, if no defense counsel is available, the court shall appoint a defense counsel ex officio, less than amended on December 8, 2020 greater than 1. When the criminal defendant is placed under detention. 2. When the criminal defendant is a minor. 3. When the criminal defendant is 70 years of age or over. 4. When the criminal defendant is deaf and mute. 5. When the criminal defendant is suspected of having a mental disorder. 6. When the criminal defendant is indicted for a case punishable with death penalty or imprisonment, with or without labor, for an indefinite term or for a minimum term of not less than 3 years. 2. Where the criminal defendant is unable to appoint a defense counsel because of poverty or for any other reason, the court shall appoint a defense counsel if the criminal defendant requests. Less than amended on December 8, 2020 greater than 3. When the court deems it necessary to protect the rights considering the age, intelligence and level of education, etc. of the criminal defendant, it shall appoint a defense counsel within the scope that does not go against the explicit intention of the criminal defendant. Less than amended on December 8, 2020 greater than. This article wholly amended on July 19, 2006. Article 34. Interview, communication and medical examination and treatment with criminal defendant or criminal suspect. The defense counsel or a person who desires to be a defense counsel may have an interview with the criminal defendant or the criminal suspect who is placed under physical restraint, deliver or receive any documents or things, and have any doctor examine and treat the criminal defendant or the criminal suspect. This article wholly amended on December 8, 2020. Article 35. Inspection or copying of documents or evidential materials. 1. Every criminal defendant and his/her defense counsel shall have a right to inspect or make a copy of any related document or evidential material for his/her case pending in a court. Less than amended on May 29, 2016 greater than 2. The legal representative of a criminal defendant, a special agent under Article 28, an assistant under Article 29, or the spouse, a lineal relative, or a sibling of a criminal defendant, who files a letter of attorney and a document certifying his/her status, shall also have the right under paragraph 1. 3. Where it is feared to seriously harm the security of life or body of a party involved in the case, including a victim or a witness, the presiding judge may take protective measures before the inspection or copying referred to in paragraphs 1 and 2, so that the personal information, such as name, etc. of a party involved in the case, shall not be disclosed. Less than newly inserted on May 29, 2016 greater than 4. The method, procedure, and other necessary matters for the protection of personal information under paragraph 3 shall be prescribed by the Supreme Court regulations. Less than newly inserted on May 29, 2016 greater than. This article wholly amended on June 1, 2007. Title amended on May 29, 2016. Article 36. Independent acts of procedure by defense counsel. Any defense counsel may undertake acts of litigation independently in his/her name, provided that the forging shall not apply where otherwise provided in acts. Chapter versus decision. Article 37. Judgment, ruling, and order. 1. A judgment shall be rendered on the basis of oral proceedings, except as otherwise provided in acts. 2. A ruling or an order shall not necessarily be based upon oral proceedings. 3. In making a ruling or order, the court may, whenever necessary, make an examination of facts. 4. The examination referred to in paragraph 3 may be assigned to a member of the relevant collegiate court, or a judge of another district court may be requisitioned. This article, wholly amended on December 8, 2020. Article 38. Form of written decisions. In regard to the decision, the document of decision shall be prepared by a judge, provided that where any ruling or order is notified, it may be made by entering it in a protocol alone instead of preparing a written decision. Article 39. Reasons for decision. A decision shall state the reasons on which it is based, provided that this shall not apply where a ruling or order which is subject to no appeal. Article 40. Contents of written decisions. 1. The name, age, occupation and address of the person upon whom the decision is made shall be entered in the written decision, except as otherwise provided in acts. 2. Where a person upon whom the decision is made is a corporation, the name and location of its office shall be stated. 3. The respective official position and name of a prosecutor who has filed the indictment and a prosecutor who has participated in the trial, and the name of a defense counsel, shall be stated in the written judgment. Less than amended on July 18, 2011. Greater than. Article 41. Signature in written decisions. 1. The written decision shall be signed and sealed by the judges who have participated in the decision. 2. Where the presiding judge is unable to sign and seal a decision, another judge shall sign and seal the decision together with a statement as to the reason, and where an associate judge is unable to sign and seal a decision, the presiding judge shall sign and seal the decision and state the reason for so signing. 3. The written decision, excluding a written judgment or other written decisions determined by the Supreme Court regulations, may be signed and sealed instead of the signature and seal referred to in paragraphs 1 and 2. Less than newly inserted on December 29, 1995. Greater than. Article 42. Methods of pronouncement or notification of decision. The pronouncement or notification of a decision in a trial court shall be made by the document of decision, and in other cases it shall be made by means of delivery of a copy of the written decision or by any other appropriate method, provided that the same shall not apply where otherwise provided in acts. Article 43, Item. The pronouncement or notification of a decision shall be made by the presiding judge. In pronouncing a judgment, she shall read the text and explain the gist of the reasons. Article 44. Cases requiring direction of prosecutor for its execution. In regard to a decision which requires the direction of a prosecutor for its execution, the copy of or extracts from the written decision or the protocol in which the decision is entered shall be forwarded to the prosecutor within 10 days from the date of pronouncement or notification of a decision, provided that the same shall not apply where otherwise provided in acts. Less than amended on September 1, 1961. Greater than. Article 45. Request for copy or extracts of document of decision. The criminal defendant or any other person concerned in the case may, at his/her own cost, request the delivery of the transcript or the abridged copy of the written decision or of the protocol in which the decision is entered. Article 46. Formation of copy or extracts of written decision. The copy of or extracts from the written of decision or the protocol in which the decision is entered shall be made on the basis of the original, provided that under unavoidable circumstances, it may be made according to a copy thereof. Chapter V. Documents. Article 47. Non-disclosure of documents relating to proceedings. No documents relating to proceedings shall be made public prior to the opening of trial except for the requirements of public interest or other probable cause. Article 48. Methods of formation of protocol. 1. Where the criminal defendant, the criminal suspect, a witness, an expert witness, an interpreter, or a translator is examined, the court officials who have participated therein shall prepare the protocol. 2. The protocol shall contain the following matters. 1. The statement of the criminal defendant, the criminal suspect, a witness, an expert witness, an interpreter, or a translator. 2. Where a witness, expert witness, interpreter, or translator has not been sworn, the reason therefor. 3. The protocol shall be read aloud to a person who has made a statement or inspected by him, her, and the accuracy of the contents of the statement shall be confirmed by him, her. 4. If a person who has made a statement requests any change, deletion, or alteration, the details of such statement shall be entered in the protocol. 5. Where the prosecutor, the criminal defendant, criminal suspect or defense counsel who has participated in an examination, raises an objection to the accuracy of the details entered in the protocol, the gist of such statement shall be entered in the protocol. 6. In cases falling under paragraph 5, the presiding judge or the judge who has participated in the examination may have an opinion as to the statement to be entered. 7. A person who has made a statement shall sign and seal the protocol after stamping a seal between pages, provided that when the person refuses to sign and seal the protocol, the reasons therefor shall be entered therein. This article wholly amended on December 8, 2020. Article 49. Protocol of Inspection of Evidence. 1. In respect to inspection of evidence, seizure, or search, a protocol shall be prepared. 2. A protocol of inspection of evidence may be annexed to a drawing or photograph in order to clarify the status quo of the object inspected. Less than amended on August 17, 2017 greater than. 3. The protocol concerning a seizure shall contain a statement as to the kinds, characteristics and appearance, and quantity of goods seized. Article 50. Contents of various protocols. The protocols under the preceding two articles shall contain the date, time, and place of investigation or disposition and shall bear the names printed and the seals affixed thereon or the signatures written by the person who has executed the investigation or disposition and the court officials who have participated therein. Provided that where a court has made the investigation or disposition on any hearing other than a trial, the relevant protocol shall bear the names printed and the seals affixed thereon or the signatures thereon by the presiding judge or judge and the court officials who have participated therein. Less than amended on June 1, 2007 greater than. Article 51. Contents of Protocol of Trial. 1. A protocol of trial shall be prepared by court officials who have participated in the legal proceedings on the date of trial. Less than amended on June 1, 2007 greater than. 2. The protocol of trial shall contain all the procedure of the trial including the following matters. Less than amended on June 1, 2007 greater than. 1. Date and time of trial and the name of the court. 2. Positions and names of judges, prosecutor, and court officials. 3. Names of the criminal defendant, legal representative, defense counsel, assistant, and interpreter. 4. Appearance or non-appearance of the criminal defendant. 5. Whether the trial was open to the public or not and the reason why it was held in closed session if it was not open to the public. 6. Reading of a statement of the facts charged or the written indictment change. 7. The fact that the criminal defendant was given an opportunity of making a statement which is necessary to protect his/her rights, and the facts which he/she has stated. 8. Matters listed in Article 48, 2. 9. Documentary and real evidence examined, and the method of examination, when an investigation of evidence is made. 10. Inspection or seizure of evidence which was done in court. 11. The gist of oral proceedings. 12. Matters ordered to be entered by the presiding judge or matters permitted to be entered by the presiding judge, at the request of a person involved in the litigation. 13. The fact that the final opportunity of making a statement was given to the criminal defendant or his/her defense counsel, and the facts which he/she has stated. 14. The fact that judgment or decision was pronounced or declared. Article 52. Exception in preparation of protocol of trial. At Article 48, 3 through 7, shall not apply to the protocol of trial and the record of the examination of a witness on a date other than the date of trial, provided that a statement made by a person shall be read to him/her upon his/her request, and if any change, deletion, or alteration thereof is demanded, it shall be recorded therein. Less than amended on December 29, 1995 greater than. Article 53. Signature on Protocol of Trial. 1. The protocol of trial shall bear the names printed and the seals affixed thereon or the signatures written by the presiding judge and the court officials who have participated in it. Less than amended on June 1, 2007 greater than. 2. Where the presiding judge is unable to print his/her name and affix his/her seal or write his/her signature on the protocol, another judge shall print his/her name and affix his/her seal or write his/her signature thereon with an additional note explaining the reason therefor. But if there is no judge who is able to print his/her name and affix his/her seal or write his/her signature on the protocol, then any of the court officials who have participated in the trial shall print his/her name and affix his/her seal or write his/her signature thereon with an additional note explaining the reason therefor. Less than amended on June 1, 2007 greater than. 3. Where any of the court officials is unable to print his/her name and affix his/her seal or write his/her signature on the protocol, the presiding judge or another judge shall print his/her name and affix his/her seal or write his/her signature on the protocol with an additional note explaining the reason therefor. Less than amended on June 1, 2007 greater than. Article 54. Preparation of Protocol of Trial. 1. The protocol of trial shall be prepared promptly after the date of trial. Less than amended on June 1, 2007 greater than. 2. The gist of major facts dealt with on a preceding trial, as recorded in the protocol, shall be informed on the succeeding trial, provided that such gist may be informed without the protocol, if the protocol for the preceding trial has not been prepared by the date of trial of next round. Less than amended on June 1, 2007 greater than. 3. The prosecutor, the criminal defendant, or his/her defense counsel may make a motion to alter a description in the protocol of trial or raise an objection. Less than amended on June 1, 2007 greater than. 4. If there is any motion or objection under paragraph 3, a record describing the purport of such motion or objection and the presiding judge's opinion thereon shall be prepared and attached to the protocol of trial for the case. Less than newly inserted on June 1, 2007 greater than. Article 55. Criminal defendant's right to inspect protocol of trial. 1. The criminal defendant shall have a right to demand to allow him/her to inspect and make copies of the protocol of trial. Less than amended on December 29, 1995 greater than. 2. Where the criminal defendant is unable to read the protocol of trial, he/she may demand the protocol of trial to be read to him/her. Less than amended on December 29, 1995 greater than. 3. If there has been no acceptance as to the demand of the preceding two paragraphs, the protocol of trial may not be used as an evidence of guilty. Article 56. Probative value of protocol of trial. Proceedings at hearings of a trial which are written in the protocol can be proved only by such protocol. Article 56-2. Stenography and audio or video recording in trial court. 1. Except in extraordinary circumstances, every court shall, upon a motion from a prosecutor, a criminal defendant or a defense counsel, assign a stenographer to take stenographic notes of a hearing in the court, in whole or in part, or make audio or video records, including those with sound recorded. Hereinafter the same shall apply, of a hearing by using an audio or video recording system, and may also order ex officio to take such notes or make such recording, if deemed necessary. 2. Each court shall keep stenographic notes or audio or video records separate from the protocol of the trial. 3. Any prosecutor, criminal defendant, or his/her defense counsel may request the court to furnish him/her with copies of the stenographic notes, audio or video records under paragraph 2, by bearing the expense for such copying. This article wholly amended on June 1, 2007. Article 57. Documents of public officials. 1. Each document prepared by a public official shall contain the date of preparation, the name of the office to which he/she belongs, and shall bear the name of the public official printed by him/her with his/her seal affixed thereon, or a signature signed by him/her, except as otherwise provided in acts. Less than amended on June 1, 2007. Greater than. 2. A document shall bear a seal stamped across a leaf, and the contiguous leaf, or measures equivalent thereto, shall be taken. Less than amended on December 29, 1995. Greater than. 3. Deleted. Less than June 1, 2007. Greater than. Article 58. Documents of public officials. 1. When a public official prepares a document, he/she may not modify any letter in it. 2. When any insertion, elimination, or entry in the original is made, a seal shall be affixed thereto specifying the change. The deleted words shall be left clear enough to be readable. Article 59. Documents made by persons other than public officials. When a person other than a public official prepares a document, he/she shall insert the date, and sign and affix his/her seal thereto, or sign. Where he/she has no seal, he/she shall use his/her fingerprints. Less than amended on December 12, 2017. Greater than. Article 59-2. Inspection and copying of finalized litigation records. 1. Any person may file an application for inspection or copying of records of trial of a case for which all the proceedings have been finalized with the competent prosecutor's office for the purpose of remedies for his/her rights, academic research, or public interest. 2. A prosecutor may place a restriction on inspection or copying of records of trial, completely or partially, if the case involved falls under any of the following, provided that the foregoing shall not apply if it is deemed that there is a justifiable ground for a person involved in the litigation or an interested third party inspecting or copying the record. 1. If the trial was not open to the public. 2. If the disclosure of the records of trial is likely to seriously undermine the national security, good public morals, maintenance of public order, or public welfare. 3. If the disclosure of the records of trial is likely to seriously defame a party involved in the case, harm such party's privacy or security of life or body of such party, or impair the peace in such party's life. 4. If the disclosure of the records of trial is likely to facilitate the destruction of evidence or escape of a person who is an accomplice, or to have significant influences on the trial of the relevant case. 5. If the disclosure of the records of trial is likely to cause a serious obstacle to the improvement or rehabilitation of a criminal defendant involved. 6. If the disclosure of the records of trial is likely to seriously infringe on the trade secret, referring to the trade secret defined in subparagraph 2 of Article 2 of the Unfair Competition Prevention and Trade Secret Protection Act, of a party involved in the case. 7. If the relevant person involved in the litigation does not consent to the disclosure of the records of trial. 3. When a prosecutor places a restriction on inspection or copying of records of trial pursuant paragraph 2, he/she shall notify the applicant of the restriction, clearly stating the reasons therefor. 4. If deemed necessary for the preservation of the records of trial, a prosecutor may furnish a person with a certified copy of the records of trial for inspection or copying, provided that the foregoing shall not apply where it is required to inspect or copy the original record. 5. A person who inspected or made a copy of records of trial shall not commit any act of undermining public order or good public morals, interfering with the improvement or rehabilitation of the criminal defendant involved, defaming a party involved in the case, or impairing the peace of such party's life, by using the information acquired from such inspection or copying. 6. If a person who filed an application for inspection or copying of a litigation record under paragraph 1 is dissatisfied with a disposition taken by the prosecutor on such inspection or copying, she may file an application for revocation of or alteration to the disposition with the competent court corresponding with the prosecutor's office in which the relevant record is preserved. 7. Articles 418 and 419 shall apply mutatis mutandis to the application for appeal under paragraph 6. This article newly inserted on June 1, 2007. Article 59-3, Inspection and copying of final written judgment. 1. Any person may inspect and copy, including electronic methods through the Internet and other electronic data processing system. Hereafter the same shall apply in this article, the written judgment for a case on which a final judgment has been made or a copy thereof, the list of evidences or a copy thereof, or the name or list of other documents or articles or information corresponding thereto, submitted to a court by the relevant prosecutor, criminal defendant, or his/her defense counsel, hereinafter referred to as written judgment, etc., at the court which keeps the relevant written judgment, etc., provided that the inspection and copying of such written judgment, etc., may be limited in any of the following cases. 1. Where the trial was not open to the public. 2. Where the case relates to a juvenile defined in Article 2 of the Juvenile Act. 3. Where such inspection and copying are likely to enable a person in accomplice relations, etc., to destroy evidence or escape easily or to have significant effects on the trial of the relevant case. 4. Where it is obvious that such inspection and copying are likely to seriously undermine the national security. 5. Where any ground referred to in Article 59223 or 6 exists, provided that this is limited to cases where a request is made by a person involved in the litigation. 2. Court officials or other court public officials shall take protective measures prescribed by the Supreme Court regulations prior to the inspection and copying under paragraph 1, to ensure that personal information, including the name entered in the written judgment, etc., will not be disclosed. 3. Court officials or other court public officials who have taken measures to protect the personal information pursuant to paragraph 2 shall not assume civil or criminal responsibilities for the inspection and copying under paragraph 1, unless such responsibilities fall on them due to their intention or gross negligence. 4. Notwithstanding the proviso to paragraph 1, a person involved in the litigation or an interested third party who has justifiable grounds for the inspection and copying may file an application for inspection and copying of the written judgment, etc., with a court official, etc., or other court public official at the court under the main clause of paragraph 1. In such cases, where she is dissatisfied with a disposition taken by the court official, etc., or other court public official on the inspection and copying, she may file an application for revocation of or alteration to the disposition with the court under the main clause of paragraph 1. 5. Articles 417 and 418 shall apply mutatis mutandis to the application for appeal under paragraph 4. 6. Methods and procedures for inspection and copying of the written judgment, etc., methods and procedures for protective actions for personal information, and other necessary matters shall be prescribed by the Supreme Court regulations. This article newly inserted on July 18, 2011. Chapter 7 Service. Article 60, Filing of reports subject to service. 1. Where the criminal defendant, legal representative, defense counsel or assistant has no dwelling or office where documents can be served, situated in the jurisdiction of the court, she shall appoint a person who has a dwelling or office situated in the jurisdiction of the court as his/her receiver and shall submit a written report signed by him, her and the receiver. 2. With regard to the service, the receiver shall be regarded as the principal and his/her dwelling or office shall be considered as the principal's dwelling or office. 3. The appointment of the receiver shall have effect for courts of all instances located in the same jurisdiction. 4. The provisions of the preceding 3 paragraphs shall not apply to those who are under physical detention. Article 61, Service by mail. 1. Where a person who is required to report the dwelling or business office or the appointment of a receiver fails to do so, documents may be served by court officials by mail or by any other suitable method. less than amended on June 1, 2007 greater than. 2. Where the document is served by mail, it shall be considered as served when the document is delivered. Article 62. Service to prosecutor. Service of documents to a prosecutor shall be made to the relevant prosecutor's office to which he/she belongs. Article 63. Cause of service by public notice. 1. When the dwelling, office, or present residence of the criminal defendant is unknown, the service may be made by public notice. 2. The provisions of the preceding paragraph shall also apply when the service cannot be made by any other means in cases where the criminal defendant is present in a place over which the court has no territorial jurisdiction. Article 64. Methods of service by public notice. 1. Service by public notice may be made only when a court so orders in accordance with the Supreme Court regulations. 2. Service by public notice shall be made by court officials by preserving the documents to be served and by putting a reason therefor on the court bulletin board to show it to the public. Less than amended on September 1, 1961, June 1, 2007 greater than. 3. The court may order publication of the reason referred to in the preceding paragraph in the official gazette or newspapers. Less than amended on September 1, 1961 greater than. 4. The first service by public notice shall become effective 2 weeks after the date of the public notice referred to in paragraph 2, provided that any second or subsequent service by public notice shall become effective 5 days after the date of public notice. Less than amended on September 1, 1961 greater than. Article 65. Application mutatis mutandis of the Civil Procedure Act. The Civil Procedure Act shall apply mutatis mutandis to service of documents, except as otherwise provided in acts. Less than amended on June 1, 2007 greater than. Title amended on June 1, 2007. Chapter 8 Period. Article 66. Calculation of period. 1. In calculation of periods, those that are calculated by the hour shall be to run immediately, while in the calculation of days, months or years, the first day shall not be included, provided that the first day of a period of prescription and detention shall be counted as 1 day irrespective of the number of hours involved. 2. A fixed period by year or month shall be calculated on a yearly or monthly basis. 3. If the last day of a period falls on a public holiday or a Saturday, it shall not be included in the calculation, provided that this shall not apply to the case of a period of prescription and detention. This article wholly amended on December 8, 2020. Article 67. Extension of legal period. A legal period may be extended as prescribed by the Supreme Court regulations in accordance with the distance between the place of dwelling or office of the person who is required to comply with procedural acts and the location of the court or the prosecutor's office, and with the extent of inconvenience in transportation and communication. This article wholly amended on December 29, 1995. Chapter X Summons and Detention of Criminal Defendant. Article 68. Summons. A court may summon a criminal defendant. Article 69. Definition of detention. For the purpose of this Act, detention shall include custody and confinement. Article 70. Grounds for detention. 1. The court may detain the criminal defendant when a probable cause exists to suspect that he/she has committed a crime and falls under any of the following. Less than amended on December 29, 1995 greater than. 1. When he, she has no fixed dwelling. 2. When there are reasonable grounds enough to suspect that he, she may destroy evidence. 3. When he, she flees or there are reasonable grounds enough to suspect that he, she may flee. 2. Every court shall take into consideration the seriousness of a crime, risk of repetition of the crime, anticipated harm to the victim, important witnesses, or such, in examining grounds for detention under paragraph 1. Less than newly inserted on June 1, 2007 greater than. 3. With regard to a case punishable with a fine of a maximum amount not exceeding 500,000 won, misdemeanor imprisonment, or a minor fine, the criminal defendant shall not be subject to detention, except as provided in paragraph 1(1). Less than amended on January 25, 1973, December 29, 1995, June 1, 2007 greater than. Article 71, Effect of custody. The criminal defendant who has been taken into custody shall be released within 24 hours from the time he, she was taken into custody when it is determined to be unnecessary to detain him, her. Article 71(2), Confinement after taking criminal defendant into custody. If deemed necessary to confine a criminal defendant taken into custody, a court may confine the defendant in a prison, a detention house, or a detention room in a police station. In such cases, the confinement period may not exceed 24 hours from the time of being taken into custody. This article newly inserted on June 1, 2007. Article 72, Detention and Notice of Grounds. The criminal defendant shall not be placed under detention until he, she has been informed of the gist of facts constituting the offense, of the grounds for detention, and of the fact that he, she may select a defense counsel, and until the court has given him, her the opportunity to defend himself, herself, provided that the foregoing shall not apply to a fugitive criminal defendant. Less than amended on November 28, 1987, June 1, 2007 greater than. Article 72(2), Method of notification. 1. The court may require a judge of a collegiate division to implement the procedure under Article 72. Less than amended on August 17, 2021 greater than. 2. Where the court deems it reasonable that the defendant has a special reason for not appearing, it may take the procedures prescribed in Article 72 through a video or any other transmission system after hearing opinions from the public prosecutor and his, her defense counsel. Less than newly inserted on August 17, 2021 greater than. This article newly inserted on October 15, 2014. Title amended on August 17, 2021. Article 73, Issuance of warrant. The summons of a criminal defendant shall be effected by issuing a summons, and the custody or confinement shall be effected by a warrant of detention. Article 74, Form of summons. A summons shall contain the name and address of the criminal defendant, the name of the crime, the date, time, and place for appearance, a statement that a warrant of detention may be issued if there is apprehension to suspect he, she may flee where he, she fails to appear without good reason, and the name and seal or the signature of the presiding judge or commissioned judge issuing the writ. Less than amended on December 29, 1995, December 12, 2017 greater than. Article 75, Form of warrant of detention. 1. A warrant of detention shall contain the name and address of the criminal defendant, the name of the crime, the gist of the facts charged, the place to bring or confine the defendant, the date of issue, the effective period of the warrant, a statement that the warrant shall not be executed after the lapse of such period whence it shall be returned to the court of issuance, and the signature and seal of the presiding judge or commissioned judge issuing the warrant. 2. Where the name of the criminal defendant is uncertain, he, she may be identified by the description of his, her countenance, build, or other features identifying him, her. 3. where the dwelling of the criminal defendant is uncertain, an entry for the dwelling may be omitted. Article 76. Service of summons. 1. A summons shall be served. 2. If the criminal defendant submits a document stating that she will appear on a date scheduled for hearing, or if the court orders the criminal defendant orally, who appears on a date for hearing, to appear on the next date for hearing, it shall have the same effect as service of a summons. 3. Where her appearance has been orally ordered pursuant to the preceding paragraph, the gist thereof shall be entered in the protocol. 4. The criminal defendant who is confined in a prison or detention house may be summoned by serving the notice of summons to a correctional officer. Less than amended on December 13, 1963. June 1, 2007. Greater than. 5. When the criminal defendant has received a notice of summons from a correctional officer, the notice shall have the same effect as the service of a summons. Less than amended on December 13, 1963. June 1, 2007. Greater than. Article 77. Requisition of detention. 1. A court may requisition a judge of a district court of the place where the criminal defendant is presently located to detain the criminal defendant. 2. Where the criminal defendant is not present in the territorial jurisdiction of the requisitioned judge, such judge may in turn requisition a judge of a district court of the place where the criminal defendant is located. 3. The requisitioned judge shall issue a warrant of detention. 4. Article 75 shall apply mutatis mutandis to the warrant of detention provided in the preceding paragraph. Article 78. Procedures for detention by requisition. 1. The judge who has issued a warrant of detention by requisition in the case of the preceding article shall, within 24 hours from the time when the criminal defendant is brought in, make an inquiry as to whether any mistake has been made as to her identity. 2. If there has been no mistake as to the identity of the criminal defendant, she shall be promptly delivered to the designated court. Article 79. Order of appearance or accompanying. The court may, where necessary, order the defendant to appear or be accompanied to the designated place. Article 80. Urgent measures. In case of urgency, a presiding judge may take measures provided in Articles 68 through 71, 71-2, 73, 76, and 77 and the preceding article, or may require a member of the collegiate court to take such measures. Less than amended on October 15, 2014. Greater than. Article 81. Execution of warrant of detention. 1. A warrant of detention shall be executed by a judicial police officer under the direction of a prosecutor, provided that in case of urgency, the execution may be directed by a presiding judge, a commissioned judge, or a requisitioned judge. 2. In the case of the proviso to paragraph 1, an order to execute a warrant of detention may be issued to court officials. In such cases, the court officials may, if necessary, demand judicial police officers, correctional officers, or court guards to provide assistance or may execute it outside the jurisdiction. Less than amended on June 1, 2007. Greater than. 3. A warrant of detention issued against the criminal defendant who is in a prison or detention house shall be executed by a correctional officer under the direction of a prosecutor. Less than amended on December 13, 1963. June 1, 2007. Greater than. Article 82. Preparation of several warrants of detention. 1. The warrant of detention against the criminal defendant may be issued in plurality to several judicial police officers. 2. In the case of the preceding paragraph, the grounds for detention shall be entered in each warrant of detention. Article 83. Execution and requisition of warrant of detention outside jurisdiction. 1. A prosecutor may, where necessary, conduct execution of a warrant of detention outside the jurisdiction or may request it to be conducted by a prosecutor who is in the competent jurisdiction. 2. A judicial police officer may, where necessary, execute a warrant of detention outside the jurisdiction or may request it to be executed by a judicial police officer who is in the competent jurisdiction. Article 84. Request for investigation to Chief of High Prosecutor's Office or District Prosecutor's Office. When the present location of the criminal defendant is uncertain, a presiding judge may commission the chief of the relevant High Prosecutor's Office or District Prosecutor's Office to conduct an investigation and execute a warrant of detention. Less than amended on January 20, 2004 greater than. Title amended on January 20, 2004. Article 85. Procedures for execution of warrant of detention. 1. In executing a warrant of detention, it shall be presented to the criminal defendant without fail. A copy thereof shall be delivered to him, her, and she shall be promptly taken to a designated court or other place. Less than amended on February 3, 2022 greater than. 2. In executing a warrant of detention referred to in Article 77, 3, the criminal defendant shall be brought before the judge who has issued the warrant. 3. In case of urgency, even if the warrant of detention is not in hand, the warrant may be executed after the criminal defendant has been informed of the gist of the facts charged and of the fact that the warrant has been issued. 4. Upon completion of the execution provided in the preceding paragraph, the warrant of detention shall be promptly presented and a copy thereof shall be delivered. Less than amended on February 3, 2022 greater than. Article 86. Provisional detention of defendant under guard. Where the criminal defendant against whom a warrant of detention has been executed is to be kept under guard, she may, if necessary, be detained provisionally in the nearest prison or detention house. This article wholly amended on December 8, 2020. Article 87. Notice of detention. 1. When the criminal defendant is detained, her defense counsel shall be notified of the gist of facts concerning the name of offense, the time and place of detention, the gist of charge, and the cause for detention, and if the criminal defendant does not have a defense counsel, the person designated by the criminal defendant from among the persons referred to in Article 30. 2. Shall be informed of the aforementioned facts of the case and of the facts that she may select a defense counsel. Less than amended on November 28, 1987. December 29, 1995 greater than. 2. The notice provided in paragraph 1 shall be made in writing without delay. Less than amended on November 28, 1987 greater than. Article 88. Detention and notice of facts charged. When the criminal defendant is detained, she shall immediately be informed of the gist of the facts charged and of the facts that she may select a defense counsel. Article 89. Interview with detained criminal defendant and medical examination. The criminal defendant who is under detention may interview with any other persons, deliver to or receive from them documents or other things, and also take medical treatment from a doctor, within the scope prescribed by the relevant statutes. This article wholly amended on December 8, 2020. Article 90. Application for defense counsel. 1. The criminal defendant who has been detained may apply to the court, the warden of a prison or detention house, or her agent, for the selection of a defense counsel after designating an attorney at law. Less than amended on December 13, 1963 greater than. 2. The court, the warden of a prison or detention house, or her agent who has received such application as referred to in the preceding paragraph shall promptly give notice of such fact to the attorney at law designated by the criminal defendant. Less than amended on December 13, 1963 greater than. Article 91. Interview or communication with persons other than defense counsel. When a probable cause exists to suspect that the criminal defendant under detention may flee or destroy evidence of a crime, a court may, ex officio or upon request of a prosecutor, forbid him, her to interview with persons other than those referred to in Article 34, prevent him, her from delivering or receiving documents or other things, or inspect or seize such documents or other things, by its ruling, provided that the receipt and delivery of clothing, food, or medical supplies shall not be forbidden nor they shall be seized. This article wholly amended on December 8, 2020. Article 92, Detention Period and its Renewal. 1. The period of detention shall be 2 months. Less than amended on June 1, 2007 greater than. 2. Notwithstanding paragraph 1. The period of detention may be renewed by a court ruling only twice by 2 months each time for each grade, if particularly necessary to continue detention, provided that it may be renewed 3 times or less if it is unavoidable and necessary for an appellate court to hold an additional hearing, upon request of a criminal defendant or a defense counsel for the examination on the evidence, or submission of a written statement to supplement the cause of appeal, or for any other reason. Less than amended on June 1, 2007 greater than. 3. Any period during which the proceedings of a trial is suspended and period for arrest, custody, or confinement before the institution of public trial in accordance with Articles 22, 298, 4, 306, 1, and 2, shall not be added to the computation of the period referred to in paragraphs 1 and 2. Less than newly inserted on September 1, 1961, December 29, 1995, June 1, 2007 greater than. Article 93, Rescission of Detention. When the grounds for detention have ceased to exist, the court shall rescind the detention by its ruling, ex officio or upon request of a prosecutor, the criminal defendant, his, her defense counsel, or persons specified in Article 32. Article 94, Motion for Release on Bail. A criminal defendant under detention, his, her defense counsel, legal representative, spouse, lineal relative, sibling, family member, cohabitant, or employer may file a motion for release of the criminal defendant on bail with the competent court. This article wholly amended on June 1, 2007. Article 95, Compulsory Release on Bail. When a motion for release on bail has been filed, it shall be allowed except in the following cases. Less than amended on December 20, 1973, December 29, 1995 greater than. 1. When the criminal defendant commits an offense punishable with death penalty or imprisonment, with or without labor, for an indefinite term or for a maximum term of more than 10 years. 2. When the criminal defendant is a repeat offender or commits habitual crimes. 3. When there are reasonable grounds to suspect that the criminal defendant has destroyed or may destroy evidences. 4. When there are reasonable grounds to suspect that the criminal defendant flees or is likely to flee. 5. When the dwelling of the criminal defendant is uncertain. 6. When there are reasonable grounds to suspect that the criminal defendant does or may do harm to life, body, or property of a victim, a person who is deemed to know the facts necessary for the trial of the case, or a relative thereof. This article wholly amended on January 25, 1973. Article 96, Voluntary Release on Bail. When a probable cause exists, a court may permit release on bail by its ruling, ex officio or upon request of those who are specified in Article 94, notwithstanding Article 95. Less than amended on December 29, 1995 greater than. Article 97, Cancellation of release on bail and detention and opinions of prosecutors.